A question from Mark from Facebook. A tenant ran to the small claims court instead of the Rental Housing Tribunal about deposit deductions. So it's one tribunal over, or one forum over another, and he's complaining about what was taken off the deposit by the landlord. So the small claims court took forever, and after some hearings, it appeared to have frizzled away. Suddenly, the commissioner pops out of nowhere and sends an email with an unsigned and undated ruling that is alleged to be immediately effective. Aside from other flaws, which aren't mentioned in the question, the viewer wants to know, is the ruling legally valid and can it be enforced?
Perfect. So let's just start with the Rental Housing Tribunal and the Small Claims Court, because Small Claims Court is something we don't talk about often here. So there's some mentioning on this particular question. So we have a number of different forums within South Africa that disputes can be taken to, and some forums are established to deal with novel sort of issues or or areas of law that can be focused on to deal with a particular issue. Okay, and it just makes dealing with issues a little bit quicker, a little bit easier, and a little bit more specialized, because you have someone who's dealing with a specific area of law. That's what they need to know about, which is different to, for instance, our High Court judges who sit often in court and are expected to know a wide range of law because they are dealing with anything that's brought towards them that may actually be in front of them. So when we are dealing with the Rental Housing Tribunal, this is a body that has been established to deal with specific rental issues. Okay, so you cannot take your divorce to the Rental Housing Tribunal. It's been established to deal with issues between landlords and tenants specifically. So it's something that's very commonly used by tenants and landlords, and it deals with those particular issues. The Small Claims Court is another body. It's deemed to be a court of law, but it deals with small claims in the sense of a monetary value. So it primarily deals with claims that are 25,000 Rand or less. Okay, so it's small amounts of money that are being disputed, and it has different sort of rules, but the scope of that small claims court is a bit wider than the Rental Housing Tribunal. So Rental Housing Tribunal is dealing with landlords and tenants. The Small Claims Court can deal with wider issues, but has a limitation monetarily of 25,000 Rand. Okay. Another important distinction between these two things is the Small Claims Court, in order to keep it cost effective for people who are coming with small monetary disputes, you're not allowed legal representation in terms of the Small Claims Court. You must appear yourself. Rental Housing Tribunal, there can be legal representation that's used in that particular form, okay, and it can be for rental amounts in excess of the 25,000 Rand, but it must specifically relate to the to a rental dispute. That's where, or at least a lease agreement dispute. Okay, so in this particular question, we're told by Mark that they went to the Small Claims Court instead of the Rental Housing Tribunal. Okay, it does seem that this obviously relates to a lease dispute, and we don't have an amount, but I'm presuming that it's below the 25,000 Rand threshold. If that is the case, there actually isn't a problem going to the Small Claims Court. You can use that form in the circumstances. Okay. So there's absolutely no problems there. There's an argument to be made. You could have gone to the Rental Housing Tribunal, but both would have had an ability to facilitate this particular issue in the circumstances. And then Mark tells us that the process took forever, and they did have some actual appearances, it seems, and then he didn't hear anything from the commission. So as far as I can see from there, again, we don't have the exact details of the appearances or whatever the case was, but this is something expected in a small claims court process. You would have had to have gone, given evidence to someone who's sitting on the bench, which is the commissioner in this particular circumstance. And what Mark says is he hadn't heard from them for a while, and then an email comes forward from an advocate who was the commissioner in the circumstances, saying that the file got lost and presenting a unsigned, undated order in the circumstances, but stating that the ruling was valid and effective from the date of the email. So what I am assuming here is that the advocate who's now emailed the order was the commissioner that actually facilitated the dispute between the parties. If that is the case and they are sending through their order, okay, that's perfectly valid for them to do that. It's simply a means in which they will disperse the order to everyone, and usually they'll take cognizance of the fact that this order is being delivered to the parties via electronic means. That's also something very common on court orders nowadays, to say this is how I'm presenting my order. I will say it's uncommon that the order would not be signed and it wouldn't have a date on it. Okay. The advocate's obviously saying here this is the date that it's going to apply from. That would normally also reflect on the court order itself. Okay. And I imagine if you went to the small claims court, you found the file, you found the order, it would indeed be signed and dated. That's, part of the process is signature and dating. But insofar as it's now been delivered to you by the commissioner, they say this is my order and it's going to be effective from today. That's perfectly straightforward as far as I see. So as far as that is concerned, I don't have any problems with that. That's probably a valid order, unless there's something arbitrary that we're not being told. You've also, Mark, said to us that there are some other errors on the particular ruling, but we don't have information on what those particular errors are. So as far as we can see from the question, this seems to me to be a perfectly valid process, unless there's something that we haven't been told. So Mark, if there is something else that you are worried about, concerned about in respect of the order, as I say, small claims court is a body that you can't use legal representation to keep costs low, to make sure people are not paying excessive legal fees. But that doesn't mean you can't reach out to an attorney to say, look, this is the ruling that's been granted against me. What can we do in the circumstances if it is incorrect? And you can still get legal advice in the circumstances. So if there is something still concerning you that I haven't touched on, something that wasn't perhaps in the question that should be taken care of, please reach out to one of our officers who will obviously be happy to help you in the circumstances.
Maybe just to add on that, because I know that people sometimes ask, so there's effectively this would be concurrent jurisdiction to a certain degree between these these different forums that one would approach and how they would work. With the Rental Housing Tribunal, is there any how to explain it? Are there any circumstances where the Rental Housing Tribunal can't become involved, or any circumstances where Magistrates Court can't become involved in instances, for example, like evictions, where there's a dispute pending before the Rental Housing Tribunal? Are there any instances where there might be conflict between these two, between those two forums, Magistrates Court and Rental Housing Tribunal?
So the only thing that comes to mind is, obviously, when we come to evictions are something very specific, and neither of these forms is really going to have jurisdiction to deal with an eviction. It's something that a court needs to deal with on an assessment basis. So anyone who goes to the Rental Housing Tribunal, and the tribunal is very good about this, if they bring an eviction, they will bump you straight to say, no, we can't handle this particular proceeding. But that's not really a conflict between these two bodies. The one thing that should be noted when you are dealing with the different bodies, although they may have concurrent jurisdiction, so they can both deal with similar issues in the circumstances, what they can't do is deal with the same issue. Okay, and by that what I mean is you must be very careful if you're approaching two bodies to not claim the same thing in two different bodies. That in a legal sense is not appropriate. And if one court comes to a conclusion, or one body comes to a conclusion, and you try to approach another body, that is what we call in a legal sense res judicata. So another body has already adjudicated upon that issue. You can't go and ask someone else to try and trial the matter, in a sense. Okay.
Sure.
And Same thing if you have an existing dispute in front of, say, the Rental Housing Tribunal, and then you approach the Small Claims Court on materially the same issue between the same parties. Okay, that is, from a legal sense, what we call lis pendens. In other words, there is a pending dispute in another forum that is going to deal with the same issue. In those circumstances, once again, the second body that gets brought that particular issue ought not to actually deal with it and should just refer you back to the initial body that is dealing with that same issue.
Sure. Awesome. Thank you so much, Nick.
Thanks, Bruno. And that brings us to the end of today. So thank you. We will see you again next week.
Cool. Cheers.
All right. Cheers.